Greetings. I'm Daniel Jacobson, Director of the Benson Center for the Study of Western Civilization. Glad you could be with us tonight. I have a couple of announcements before our event. First, I hope you can join us for the last couple of talks in our series, The Canceled. They will be Professor Daniel Mahoney on Tuesday, April 13th at 6 p.m. Mountain Time. And then the following Monday, April 19th, Kevin Williamson, also at 6 p.m. Mountain Time. I'll let you know that tonight, if you'd like to ask questions of our speaker, if you move your mouse, you'll see at the bottom of your screen a little Q&A button. If you click on the Q&A throughout the talk at any time, you can enter a question there, and we'll be having a Q&A after the talk. So I hope you will ask any questions that you have. I'll be happy to read them. Tonight, it's my great pleasure to welcome Professor Michael Basler. Professor Basler is Professor of Law and the 1939 Society Scholar in Holocaust and Human Rights Studies at Chapman University's Fowler School of Law. He's the holder of previous fellowships at Harvard Law School, the U.S. Holocaust Memorial Museum in Washington, D.C., and Yad Vashem in Jerusalem, the Holocaust Remembrance Authority of Israel, where he was the holder of the Baron Oppenheim Chair for the Study of Racism, Antisemitism, and the Holocaust. Professor Bazyler is the author of 7 books, more than 24 law review articles, book chapters, and essays on subjects covering law and Holocaust and restitution following genocide and other mass atrocities. His book, Holocaust, Genocide, and the Law, A Quest for Justice in a Post-Holocaust World, from Oxford University Press, is the winner of the 2016 National Jewish Book Award. His writings have been cited by the US Supreme Court, and he's testified in Congress on the subject of Holocaust restitution. Tonight, he's going to be speaking to us on Hitler's willing business partners and the search for post-Holocaust justice in the United States. Professor Bazyler.
Thank you so much. Dr. Jacobson, can you see me? Can you hear me?
Yes, it's all good.
Yes.
Go ahead.
Okay, very good. Thank you. All right. It's really my pleasure to be with you today. I want to thank everybody at the Benson Center for inviting me. Professor Daniel Jacobson, the director of the center staff, Betty, Lily, our webinar maven, Brian Bishop. And we're really coming here, and I get to speak on a really auspicious week, auspicious day, because tomorrow it's Yom HaShoah, a Holocaust Remembrance Day. And so it's really an important time to remember as to what occurred during the years 1933, 1945 in Europe, and to learn the lessons from that. I also want to express my gratitude to Dr. John Eastman, the 2020-21 visiting scholar at the Benson Center, who extended the original invitation to me to speak to you today. Thank you, John. I want to also especially acknowledge 2 individuals, Judah Gribitz, the Special Master, and Sherry Reig, the Deputy Special Master of the Swiss Bank's Claims Class Action Settlement, which in the presentation, as you will see, I call the mother of all Holocaust restitution settlements. I'm told that both Mr. Gribitz and Ms. Reig are in the Zoom audience with us, and Mr. Gribitz celebrated last week his 92nd birthday. So happy birthday, Judah. Last but not least, I want to acknowledge my niece, Rachel Weber, who is a graduate of the University of Colorado, class of 2011. I just want to show you. Here's my long sleeve t-shirt that I had since that time that I still wear on many occasions. Thank you, everybody. So in looking at this topic, I want to begin with the following general statement. It's a truism that no amount of financial remuneration can compensate the victims of a genocide for the lives lost, never mind for the monetary damages suffered. Yet part and parcel of every genocide is theft. Hence the term pillage to describe the fate of those subject to a military defeat. Monetizing losses from a mass atrocity and then seeking compensation from the wrongdoers, however, leads to a heated and sometimes overheated discourse. Such discourse is in proportion to the painful emotions that arise from the tragedy. To put it simply, money and genocide don't go well together. Historian Michael Maris begins his book on Holocaust restitution, which he calls Some Measure of Justice, with the words, "spit at it." These were the words uttered by journalist Leon Wieseltier to his Holocaust survivor mother about what to do with the money Germany was offering as restitution payments to Holocaust survivors. The late Professor Elie Wiesel, in his preface to Ambassador Stuart Eisenstadt's book on Holocaust restitution, Imperfect Justice, speaks of feeling, and I quote, reluctant to define the greatest tragedy in Jewish history in terms of money. Let me first tell you how the economic dispossession of the Jews was a critical part of Nazi policy towards the Jews. One of the first actions taken by Hitler's stormtroopers, was to paint the word Jude, Jew, on the storefronts of Jewish shops as part of the state-sanctioned call on April 1st, 1933, for an economic boycott of all Jewish businesses. Hitler came to power on January 30th, 1933. So you can see this is just right at the beginning of the Nazi era. Law became an important part of Nazi thievery, depriving Jews not only of their civil rights, but also possessions. Regulations mandated the Jews detail all their property on government-issued forms, and such registration was the first step in the process of both legal and extra-legal confiscations. Jews in the Reich, fortunate enough to obtain an exit visa, had to leave most of the property behind as the price of departure. Part of the evil genius of Adolf Eichmann, one of the main architects of the Holocaust, who was caught in Argentina and then tried in Israel in 1961-62, was to create a one-stop thievery shop that he called innocuously the Central Office for Jewish Immigration, where Jews within the course of one day would legally turn over all their assets to the state in exchange for an exit visa that was valid to leave the country for 60 days. Fire sales of Jewish property became common in Nazi Germany, as Jews desperately sought to sell their assets at distressed prices. Jew auctions, and that was the name that was used, also became a normal part of the German economy, where properties of the departed Jews would be sold off at bargain basement prices. As a result, according to Holocaust historian Peter Hayes, by the summer of 1939, so this is now 6 years later, the Third Reich had reduced German Jews to poverty. The result, according to Hayes, was, quote, a robbery on a scale scarcely seen in European history. All the more so because the plunder of the Jews outside of Germany during World War II took place alongside the looting of even greater quantities of precious metals, stocks, bonds, cash, artworks, enterprises, real estate, and labor from both Jewish and non-Jewish sources in the occupied countries. Upon takeover of foreign territories, the properties of the Jews were likewise confiscated and sent back home as part of the social safety net instituted by the Nazis to keep the civilian population happy. German historian Götz Ali, in his monumental 2008 book, Hitler's Beneficiaries, brilliantly shows how the welfare state created by the Nazis kept ordinary Germans loyal to Hitler through the privations of war by keeping them supplied with an abundance of goods stolen from Jews and other victims in German-occupied Europe. Let me now go to my slides and a screen share. Let's see here. Okay. Can you folks see that? Daniel?
I can see it. I think if you maximize it, then we'll be able to see your slides even better.
Okay, I thought I did.
One over from where you are.
Okay. Okay. The technical part of it. Okay, let me stop share one more time. And get screen share. Okay. But that's not maximized, right?
Not yet.
Not yet. Okay.
All you have to do is hit from beginning on the
There it
left-hand side.
Okay. How is that, folks? Is that good?
Great.
Yes?
Yes.
Okay, very good. All right. So the first slide is I want to show you, this is the Auschwitz concentration death camp in German-occupied Poland. And you can see from all over Europe where the Jews were sent to their deaths, where over 1 million Jews were murdered. And those that had survived through a slave labor program. So let me show you, this is the slide of the Auschwitz-Birkenau death camp, in which you have the arrival of German Jews in 1944 from Hungary. This deportation process began in 1941 and went into 1942. You can see the individuals arriving from all over Europe with their possessions. They would be told they were coming in for resettlement. They were suspicious as to what was going on. They didn't know. And the slide shows as they're coming off the trains with their possessions. They were separated into those that went into forced labor and those that were sent to the gas chambers. And if you look at the slide, you actually see in the foreground right on top, you can see the crematoria that served
Excuse me, Michael. I think if you advance the slide, we will be able to see it larger. You're looking at the next slide. I think that you're in the notes view.
Okay.
But if you advance it, we'll at least get it on the main screen.
Is that? Okay. So you're looking at something different than I'm looking at? Hold on. Okay, are you seeing Hitler's willing business partners?
That's what we see in the large view. And then we also see a little next slide, and you're talking about the next slide. So if you advance it, that will be the larger slide on the screen. If you can get out of notes view, that will be the only slide on the screen.
Okay. Let me try again. Okay. How's this?
Perfect. Great.
Okay, thank you. All right, so I showed you this slide of Auschwitz. I showed you the slide of the Jews from all over Europe arriving in Auschwitz, coming off the trains with their goods. They were being told that their goods would be given to them. A selection process was done on the ramp. And then those that were selected for extermination in the human slaughterhouses were sent to the gas chambers. And then you have here in the on top, you can see the crematoria that were used to burn the bodies. But the focus here is on the goods. So the goods were then put in large warehouses, nicknamed by the inmates, as Canada, which was Canada to them was a place of seeming abundance, where goods taken away from the arriving Jews were sorted and then stored. And the same trains that would bring Jews to their deaths were then used to ship the plunder back to Germany. In addition to the goods, you have the wedding rigs that you see that were found in Auschwitz after the war. and included such dispossession as the prying of gold teeth from the mouths of Jews that were gassed, and then especially designated prisoners that were called barbers, and whose job was to take the possessions of the Jews and to be put to good use. The gold was melted down and deposited in SS bank account or sold to the SS National Bank, to the Swiss National Bank in neutral Switzerland. Now, a conundrum was created by the perversity of German SS law, which legally allowed for genocide, but punished unsanctioned private theft. A letter written in 1942 by SS head Heinrich Himmler to his family stated, and I quote, "We have a moral right, an obligation to our people to take the people who want to kill us and kill them. But we have no right to enrich ourselves with a single fur, a watch, a single mark, a cigarette, or anything else." In his next letter home, however, Himmler mentions a gold bracelet that he was sending along to his wife and a fur coat that would be forthcoming. Both presumably were booty stolen from Jewish inmates of his SS concentration camps. Now, upon Germany's defeat, the goal of returning what was stolen was a high item on the Allies' agenda, that the primary focus was to return property stolen from the occupied states rather than from individuals. During the last 70 years, there have been three key periods of what I call Holocaust restitution, or the Holocaust restitution movement. The first period was from 1945, right after the end of the war, to 1949, when the Allies occupying Germany sought to recover and return assets stolen by the Nazis throughout Europe, and returning Jewish property was a part of that return booty. The second period began with the return of German sovereignty and the creation of the Federal Republic of Germany, or West Germany, in 1949. And this period featured the treaty between West Germany and Israel in 1952 to make payments to the new state of Israel for the next decade. The third period began in the 1990s, more than a half century after the Second World War, when surprisingly, the subject of Jewish losses rose again, but this time in a very unusual place, the courthouses of the United States. And I'll speak about that later. So with regard to the first period, so following Germany's unconditional surrender on May 9, 1945, the Allies established the series of laws to turn back the massive theft within Germany that took place during the last 12 years, 1933, 1945, of Nazi rule. Forcing the Nazis to forfeit their property was an important part of their strategy in their control of post-war Germany, as important as putting the wrongdoers on trial at Nuremberg. US Army Directive 1067 in April 1945, and this was even before the end of the war, called for the seizure of, quote, property, real and personal, owned and controlled by the Nazi Party, Adolf Hitler, at that time he was still alive, his chief associates, other war criminals, and all persons who have participated in planning or carrying out Nazi enterprises. After occupation, there were a number of military laws that were passed, some dealing specifically with property restitution. The most relevant was US military law number 59, which called for restoration of identifiable property that had been seized on racial, political, or religious grounds. It also established an important principle that a successor organization, and that's a term of art under German law, successor organization, had a right to claim the assets of those who had perished and who had no heirs. The father of this Holocaust restitution movement during this period is a man very much I admire, and I want to talk to you a little about him, and that's Ben Ferenz. Now, Ben is the last living Nuremberg prosecutor. He graduated from from Harvard Law School in 1943, went in the army, fought on D-Day in General Patton's army, but because he was a lawyer, he then became a war crimes investigator and then became a prosecutor in Nuremberg. But at the end of Nuremberg, he stayed in Germany to deal specifically with restitution of Jewish property. And that's why I call him the father of Holocaust restitution. So here's Ben with his associates. All his 4 children were born in Nuremberg and working on returning the assets that were stolen from the German Jews. And here's Ben in his office. He's not in the courtroom, working on the subject. And then he documented his efforts in a book called Less Than Slaves, Jewish Forced Labor and the Quest for Compensation. And in the book, he talked about the restoration not only of the German of communal property, but also payment to, you see individuals on the screen who worked as slave laborers for the various German companies during the war, exploited as slaves. And the reason that he calls them less than slaves, because think about a slave, it's personal property. You don't want to go ahead and lose that property. These individuals were less than slaves because as soon as they perished, you can just get a requisition from the concentration camps with a new batch of workers who would work until die from their labor. Now, the second period of restitution took place in 1951. Let me just show you though, Ben Ferenz, this is at age 27 in Nuremberg. He became the prosecutor for the Einsatzgruppen trial, which is one of the 12 trials that took place at the end of the first trial at the IMT. Here's Ben, he's the chief prosecutor, age 27. He never tried a case in his life. There's a book I co-wrote called Forgotten Trials of the Holocaust. And we, talk about this trial. And in fact, the publishers, NYU Press, chose the cover for the book. And you can see Ben Ferenz with 2 German attorneys in the courtroom, putting on trial these special action murder squads. They're responsible for the death of over 1 million Jews. The verdict that was reached was on April 10th, 1948. The anniversary is coming up in 4 days. Every year I call Ben and I congratulate him and I ask him to tell me something about the verdict and what he remembers. On trial were 22 SS German generals who stood trial for war crimes, crimes against humanity, and they were responsible for the murder of over 1 million Jews and other victims, and what we call Holocaust by bullets. This is the first stage of the Holocaust before the creation of these human slaughterhouses in Auschwitz, where basically the German troops would come in after securing a certain territory, collect all the Jews and telling them to set up in place, put in trucks, go into the countryside where they were shot by bullets. So this was the Holocaust by bullet stage. This stage was really very much traumatic from the point of view, obviously the victims, but to the perpetrators, so that the Germans try to figure out a more expeditious way to go ahead and do the mass murder. And this is why the idea of the concentration camp and the death camps in German occupied Poland came about. And this is where Auschwitz comes from, where over 1 million Jews were murdered in these human slaughterhouses. Ben celebrated his 100th birthday. You can see this is a commemoration by the International Criminal Court. He's the last living prosecutor of the Nuremberg trials. And Ben, on March 11th, turned 101 years young. If you want to learn more about Ben, you can go to the website, benferenz.org, and you'll find plenty of information. Photos. Is really just an incredible individual. So when Ben finishes his work, he ended up coming back to the United States. Germany returned to sovereignty. There was the creation of 2 Germanies, East and West. East Germany was not interested in paying any compensation, but West Germany was. So on September 27, 1951, the first West German Prime Minister, Konrad Adenauer, made a historic speech, announced that Germany was ready to go ahead and to engage in negotiations with Israel. And he said, this is 1951, the federal government and the great majority of German people are conscious of the immeasurable suffering that was brought to bear by the Jews of Germany and the occupied territories. And we need to there's an obligation to make material, moral and immaterial amends during that time. And as a result of this, you had an agreement that was passed called the Luxembourg Accords. And under the Accords, see 1952, $845 million in reparations was paid to the state of Israel. And in addition, there was a second part of the agreement in which you had the creation of a specially created pass-through entity called the Conference on the Jewish Material Claims against Germany, otherwise known as the Claims Conference, which still exists today. It's based in New York, by which Germany would make payments to a limited class of survivors worldwide through the Claims Conference. And to this day, German law recognizes the Claims Conference as the sole NGO, the sole representative of the Holocaust survivors to deal with Germany for Holocaust-era restitution claims. Now, these agreements with Germany were and still are revolutionary. Nehemiah Robinson, who was one of the Jewish lawyers working for the Claims Conference, explained at the time, and I quote, "In no previous case in history had a state paid indemnification directly to a people, most of them individuals, most of them not even its own citizens. David Ben-Gurion, who was Israel's first prime minister, who gave the green light to negotiate directly with the German people, with the Jewish people's former dreaded enemy, explained, for the first time in the history of the Jewish people, oppressed and plundered for hundreds of years, the oppressor and the plunderer had to hand back some of the spoil and pay a collective compensation for part of the material losses." Elazar Barkan, who's a professor at Columbia University, calls the Israeli-German agreement, quote, "the moment at which the modern notion of restitution for historical injustices was born." But there was a major problem. For Israel, entering into an agreement with a state that represented the tormentors of the Jews was one of the most painful decisions that the state had to make. A common mindset among the worldwide Jewry after the war was to shun all things German, whether visiting the country or purchasing German products, German cars being the most visible. And one cannot underestimate the loathing that Jews worldwide and survivors in particular felt toward Germany after the war. So when word leaked out that Ben-Gurion's government was negotiating with West Germany, massive demonstrations took place against accepting such blood money. They were the first major street demonstrations in the new state of Israel took place as a result of this agreement. Now, Israel badly needed German aid, and so the Israeli parliament, by a vote of 61 to 50, agreed to negotiate with Germany. And according to an Israeli journalist, Tom Segev, the day that the parliament vote was termed was called the Day of Judgment. The choice of individual survivors of whether to file an application for compensation also posed a moral dilemma, with a small but a significant number of survivors refusing to accept monetary payments from Germany. And I remind you of the son telling his Holocaust survivor mother, spit at it, when there was a possibility, to get the money. You will see, this is a demonstration in 1952. There's a slide of that. This is the future Prime Minister, Menachem Begin, who was the leader of the opposition, protesting against this agreement. And the sign in Hebrew reads, "Our honor shall not be sold for money. Our blood shall not be atoned by goods. We shall wipe out the disgrace." But you can see practically the country needed it, and therefore the agreement ended up coming about. Now, fast forward now to more than 50 years later, and we enter into the third stage of Holocaust restitution. The modern era of the Holocaust restitution campaign had a very strange beginnings. It started with 3 class action lawsuits filed in New York federal court in 1996 against Swiss banks for the failure to return bank accounts and other deposited assets by Jews in neutral Switzerland during the Hitler era. The private banks and the government Swiss National Bank, which is the equivalent of our US Federal Reserve Board, were also accused of trading with Nazi Germany and looted assets, including gold stolen by the Nazis, the gold that I showed you, and the gold rings, and the fillings, the gold fillings in the teeth. the consolidated class action lawsuits against the Swiss banks were heard before Brooklyn judge Edward R. Corman, and sort of the hero of this litigation. These cases, filed in 1996, settled in 1998 for $1.25 billion, which the banks paid into a class action settlement fund, which Judge Corman, with the assistance of Special Master Judah Gribetz, who I mentioned, and Deputy Special Master Sherry Reed, administered for over 20 years, devising and overseeing a restitution process relating to unreturned Holocaust-era Swiss bank accounts, slave labor, looting, refugee claims, not just for Jews, but also for other victims. And under the settlement, the other classes of victims included Romani, commonly known as gypsies, Jehovah's Witnesses, gay men persecuted by the Nazis, and disabled Nazi victims. The program distributed over this 20-year period nearly $1.3 billion that went over to 458,000 Holocaust victims and heirs worldwide. And in my book, Holocaust Justice, I call the Swiss bank settlement, as I mentioned, the mother of all Holocaust restitution settlements. I believe that if the litigation against the Swiss banks had failed, there would have been no momentum to proceed further with the other Holocaust restitution claims in the American courts, which continue to this very day. So in my slides, I show you some books that were written in the 1990s, pointing the spotlight at Switzerland, a country that was really known for, Heidi, chocolates. Nobody was thinking about Switzerland being the perpetrator. And so this idea came out. Holocaust survivors then began testifying about this. This is Holocaust survivor Estelle Sapir in New York, holding a photo and testifying about her father, Joseph Sapir, who had opened a Swiss bank account. And when she went after the war to collect an account, they said to her, "Where's the death certificate of your father?" And her answer is that they didn't give out gift certificates in Auschwitz. "Well, I'm sorry, we can't give you the money back." This is Judge Corman, who was the chief judge in Eastern District of New York in Brooklyn, who went ahead and was in charge of the settlement. And that, as I said, began in 1998. And this is the letter that was submitted by Special Master Judah Gribetz and Deputy Special Master Sherry Reed to Judge Corman, basically with a final report on March 28, 2019, saying it has been our great honor to have assisted the court in formulating, establishing, and overseeing this claims process, where you can see $1.285 billion was paid to more than 458 Holocaust victims and other heirs. Now, as a result of the settlement, those, as we say, the floodgates of litigation have opened. And so other lawsuits began to be filed for Holocaust restitution in American courtrooms throughout the United States. The second class of lawsuits was against European insurance companies who ended up selling insurance policies to Jews prior to the war. Some of them were life insurance policies, but who refused to pay on the policies after the war. So when survivors came with a copy of a policy like this, the answer would be proof to us that the life insurance, the person on whose life was insured is dead. Where's the death certificate? The same things what the Swiss banks were saying. You have another life insurance policy, and this is a case that was filed in state court in California by the Moore family. And this was a family that was in the Moore's turn, who was a dealer, a wine dealer, a merchant in Czechoslovakia. And they actually had a copy of the policy that was issued by this Italian insurance company, showing that it was issued to Moore's turn. He died. His son survived, went to the insurance company in Prague, asked for payment. He was destitute, and they threw him out of the office saying, "I'm sorry, you don't have the death certificate. There's nothing that we can do about it." This lawsuit also settled. As a result of that, you then have litigation that was filed against class action against German companies for profiting from the slave labor of Nazi victims. These were the same unresolved issue that I mentioned the Nuremberg prosecutor Benjamin Ferenz was handling in occupied Germany and West Germany after the war. Finally, there was looted art. This is, by the way, this you have on the screen, Himmler, Heinrich Himmler, the head of the SS, inspecting the IG Farben plant in Auschwitz, where the slaves from Auschwitz were then requisitioned to work as slave laborers. You had the company Krupp using slave laborers. You had, this is German slave labor for BMW working. Another BMW plant, they're making munitions, but they're working for a private German company. And you have also women that were working as slave laborers. Those individuals, in one sense, were lucky because they didn't have to be in Auschwitz, and many of them survived because they were working as slave laborers inside rather than outside. And therefore, many of the survivors were those that came as slave laborers. Finally, there was the claim of Nazi-looted art. Museums, galleries, and private collectors, both those located in Europe and the United States, began to be sued in American courts for the return of art that was stolen by the Nazis throughout Europe from Jewish families and came into the hands of these persons in these museums after the war. I'm going to show you the settlements against the German companies also resolved, and this was in the year 2000. It was a class action settlement, and that was done through the intervention of the Clinton administration, in which the German companies and the German government paid $5 billion in order to pay compensation to the former slave laborers. This was as you can see, it's not a Mercedes-Benz ad, it's actually a naming and shaming ad that was put in the New York Times by Holocaust survivor groups, indicating the sorry history of Mercedes-Benz. You see the design, performance, step, labor, and then it talked about the history. People would remember when they were buying a German car, who were they buying for? And so this kind of pressure plus the litigation brought Germany to the bargaining table. They settled, and there was an agreement between the United States and Germany by which this fund in Germany was created. The individual payments to these slave laborers were not very large. If you were a Jewish survivor and you survived the slave labor program, you were the less than slave category, you would get a payment of $15,000. If you were a non-Jew who was working under a less harsh regime, then you would get $7,500. And these are individuals in the year 2000, many years after the war, who finally ended up getting some compensation. The litigation with regard to art came as a result of the theft. And you can see this is American troops going in some of the caves and tunnels in which art was preserved, which was stolen from the Jews and museums and art collectors throughout Europe. Now, with regard to this art, this Nazi-looted art litigation continues to this very day. The most successful suit, and the one that's most well known, happened in 2006, where after 6 years of litigation, a case came before the United States Supreme Court, brought by Maria Altman, who was an elderly Holocaust survivor from Austria living in Los Angeles, with the assistance of her young lawyer, Randy Schoenberg. And they recovered from the Austrian National Gallery artworks by the Austrian modernist Gustav Klimt, stolen from their family by the Nazis. Altman and her fellow heirs sold one of these paintings, I'll show this in a moment, for $135 million, which at that time was the highest price ever paid for a single work of art. The story is well told in the Hollywood drama. You might have seen this, Woman in Gold, with Helen Mirren playing Mrs. Altman and Ryan Reynolds playing the young attorney, Randy Schoenberg. So the case came to the United States Supreme Court. It was against the Vienna Museum. This is the painting, Adele Blauer Guan, Woman in Gold, painted in 1907 by Gustav Klimt. This is the Jewish family, the Black Bauers, who end up owning that painting. Mrs. Black Bauer, Adele, who is the subject of the painting, you see, this is, she was painted, is that she died of meningitis before the war. Ferdinand lived after the war. In 1938, he had to run and barely escape from Nazi-occupied Austria, died in 1945 in Britain. And then the paintings were then stolen by the Nazis, ended up in the Vienna National Belvedere Gallery. And this is what the lawsuit was about. This is Maria Altmann with her husband Fritz, when they also escaped from Nazi Germany, and they came to Los Angeles in 1939. This is now, you see Maria Altmann then, and Maria Altmann later when the painting was recovered. This is the attorney Randy Schoenberg. And I love this poster. This is the movie poster for the movie, Woman in Gold. And you can see of the movie posters for the movie, this is my favorite. It shows the lawyer with the Holocaust survivor. He's holding her by her arm, leading her from the Nazi darkness. There's the swastika into, the light. And the statement here, you can't see it, says the fight for justice never ends. So basically what the theme of this Holocaust restitution movement is the ability of Holocaust survivors of many years trying to get some kind of recognition, restitution, finally being able to get some measure of justice in American courts. And Nazi looted art, you can see, is the one that is most remembered. How did this litigation arise? Okay, it came as a result of a law that was passed by Congress in 1976 called the Foreign Sovereign Immunities Act. And this law codified in American law the theory of what's called the restrictive theory of immunity, which when a lawsuit is filed against a foreign country or any of its entities, like a state museum, that lawsuit, the country and the entity that's sued is immune from litigation because of sovereign immunity, unless there is some kind of exception to this immunity. And it said the law sets out a number of exceptions. And Mr. Schoenberg was able to show that this act was both retroactive, which is what the Supreme Court agreed with, and one of the particular exceptions actually applied to the taking in this case. This is the law, this is the exception. So you see it says a foreign state shall not be immune in any case in which rights and property taken in violation of international law are an issue, and that property is owned or operated by agency instrumentality of the foreign state, that would be the museum, and that agency instrumentality engages in a commercial activity in the United States. Now, this is the law that was used, and this was the reason why compensation was, possible. If you see the movie, the most important part of the movie is when Randy Schoenberg goes into a bookstore in Westwood and finds these two books, Gustav Klimt, Painter of Woman, and this book. You see who's on the cover, Adele Black-Barrow 1. And the argument that was made is that as a result of this museum taking this painting that was taken in violation of international law and now owned operated by the museum, and that museum is engaged in a commercial activity in the United States by doing what? Selling these books, engage in commercial transactions in the United States. And therefore it fit within this exception. This is the painting now at the Newell Gallery in New York, and that Ronald Lauterbach. If you're ever in New York, I very much recommend seeing it. Before I went to New York, it was shown at the LA Museum, here in Los Angeles. And it's just stunning. I mean, no reproduction can really show how beautiful, it is. Now, as a result of this, you had other lawsuits coming about from this. And then this litigation continued. And unfortunately, and this is the last part of my presentation, you had a lawsuit that was filed in the United States against a German museum in Berlin, arising from a Nazi art sale that took place in 1935 in Germany. What happened in that situation? And this is the language from the Supreme Court itself when it decided that the lawsuit will not be allowed to proceed. The lower courts, using the precedent of Altman versus Austria, said, yes, this exception applies. Looking the opinion of Chief Justice Roberts, you can kind of read between the lines, and this is the way the case begins. You can tell which way it's going to come out. This case concerns several dozen medieval relics and devotional objects known as the Weltschatz, the treasure shots of the German Welf dynasty. Okay, the collection ended up in a chapel in 1671 and later to Switzerland for safekeeping after World War I. It's now ended up in a Berlin museum. You can see it here. He then continues. This is actual language from the opinion. During the waning years of the Weimar Republic, a consortium of 3 art firms owned by Jewish residents of Frankfurt purchased the Weltschatz. By 1931, the consortium had sold about half of the collection pieces to museums, including the Cleveland Museum of Art, where half of the Weltschatz is there. The other one is at the Berlin Museum. What happened? And again, back to the opinion. Conditions facing the consortium changed dramatically after the collapse of the German economy and the rise of Nazi government. After ascending to power, Hermann Goering, Adolf Hitler's deputy and the Prime Minister of Prussia, became interested in the remainder of the Weltschatz. Now, the opinion really minimizes the role of Hermann Goering by just one sentence, because who was Goering? Goering was the main defendant in the Nuremberg trial. It's right here. Okay, he is the one that was successor to Adolf Hitler. He was the one who was the number 2 person in the Nazi hierarchy, who was the head of the German Air Force. And according to this opinion, kind of matter-of-factly, says the complaint alleges that Goering employed a combination of political persecution and physical threats to coerce the consortium into selling their remainder pieces to Prussia in 1945 for approximately 1/3 of its value. What happened afterwards? 2 of the consortium members fled the country following the sale, and the 3rd died in Germany shortly thereafter. So these are German Jews. All right. The question that the court was faced, the one I mentioned before, does the expropriation exception in the FSIA give federal courts jurisdiction to resolve the claims against Germany and its Berlin Museum? And writing for the unanimous court, that's a 9-0 opinion. So all 9 justices, all 8 other justices went ahead and signed off on the opinion held that this exception permitting suit for cases involving rights and property taken in violation of international law does not extend to a sovereign's taking of the property of its own nationals. And for this reason, Berlin, Germany, and the Berlin Museum cannot be sued in the United States. So the devil is always in the details. So why did the Supreme Court decide this? The reason was what we call, and teach law students, the parade of horribles, opening the floodgates of litigation. What happens if we allow this lawsuit to proceed in the United States? And Chief Justice Roberts says, as a nation, we'd be surprised and might even initiate reciprocal action if a court in Germany adjudicated claims by Americans that they were entitled to hundreds of millions of dollars because of human rights violations committed by the United States government years ago. There's no reason to anticipate that Germany's reaction would be any different were American courts to exercise the jurisdiction claim in this case. Meaning, we don't want to open up the can of worms. If we allow this suit to proceed, look all the terrible things that are going to happen. But then the question becomes, okay, what about these individuals? This lawsuit was allowed to proceed. What's the difference? Well, the difference, according to the court, was that at the time of the expropriation of the woman in gold, Ferdinand Bloch-Bauer happened to have, even though he was living in Austria, happened to have a Czech passport. And therefore, the expropriation was not of a German or an Austrian by its own country, but that of a foreigner. So according to the opinion, and this is the one ray of hope they held out, they say we not consider an alternative argument noted by the heirs that the sale is not subject to this domestic takings rule because the consortium members were not German nationals at the time of the confiscation. And the Supreme Court ordered the Court of Appeals to consider this argument in the court below. And that's why the case is now going before remand in order to decide. Now, let me give you some background facts on remand. Hitler is appointed as Chancellor of Germany on January 30th, 1933. The sale took place on June 14th, 1935 in a hotel in Munich as anti-Jewish riots were going outside. And the claim that Germany is making is this was an arm's length commercial sale. And it was made as a commercial sale between the Prussian government and these three German Jews. Well, this is the status of German Jews after Hitler came to power. March 10th, you see this photograph of Dr. Michael Siegel being paraded on the streets of Munich because he went to complain to police for his client, who was ended up being picked up by the Nazi stormtroopers. The kind that he was made to carry in shame. I will never again complain to the police. So this is the status, you can see the real status of German Jews as soon as Hitler came to power. So he comes to power in January 30, 1933. This took place on March 10th, 1933. And then you have in 1935, and this is September, the Reich Citizenship Law that basically strips Jews, of any political and civil rights. Now note that the sale took place on June 14th, 1935. So legally, up until that time, you could make the argument that there were still nationals of Germany, but they really have no civil rights whatsoever. And that's the argument that's going to be made before the lower court. We really don't know whether the lower court will accept this or not. And we shall see whether a measure of justice will be considered in this case, or whether this is going to be the case that's going to be decided different than the Altman and case in which there's not going to be any restitution or compensation. Let me show you. This is the passports that were given out to Jews, and you had to have a stamp indicating J, that the holder of a passport, even though the person was a German citizen, was a Jew. This is the passport of another German Jew. And in fact, under the law, every single Jewish citizen had to have within their passport a middle name, Israel, for if you were Jewish, and Sarah, if a Jewish man, and Sarah, if you were a Jewish woman. You see this passport is given out stamp, the Nazi stamp in Vienna. All right. I will go ahead and stop here. I just want to go back and show you the book that I wrote came out in 2016. And this is of Maria Supikova, who was one of the witnesses, 15 years old, at one of the Nuremberg trials. She was a person who was ended up, her entire family was killed except her mother. She was saved because she had blonde hair and blue eyes, and therefore was Germanized and made to live with other Germans. By the time the war ended, she didn't speak any Czech. She met her mother after the war. She couldn't even speak the Czech to her. She only spoke German. The mother survived for 1 year and then died. Maria then ended up going back to the Czech Republic and going back to the town where this massacre occurred in Lidice. And here she is in 2017 with the mayor of the town of Lidice with Michael Basler's book. I have to tell you, it was one of the most happiest days of my life where I get to meet her, because here she is on the cover of the book and I get to meet her in person. And here I am meeting her in April 2017. Okay, folks, I will stop now. Thank you.
Thank you, Michael, for a fascinating and chilling talk and slideshow. A couple of announcements. First, a reminder that if you scroll over on your Zoom window, you'll see a Q&A button at the bottom. You can ask questions by pressing that and typing in your questions, and I will pass them on to Professor Basler. Also, Professor Basler's books are all available at Michael Basler That's Bazyler, spelled Bazyler. And of course, you can also look it up on our website to find the spelling of his name. Okay, let me start with this question. The phrase willing business partners. Let me start with a caveat that everyone has to make in these contexts, which is that comparisons to the Holocaust are always dubious. That said, the phrase "willing business partners" reminds me of things that are happening today. The Chinese Communist Party, in particular, is using. There's ample evidence that they're using slave labor and perhaps committing genocide of the Uyghurs and some other ethnic groups currently. And yet we see not just that American companies do business in China with the Chinese government, but that companies like Disney, the NBA, and the BBC all seem to, I think clearly are doing things like restricting the speech of their employees, for instance, and cutting their movies, making their films specifically in order to try to capitalize on profits in the Chinese market, and as well as taking advantage of slave labor, or very close to slave labor. I don't think, perhaps we don't have all of the evidence on it yet. I wonder if you have anything to say about the comparison between what's going on in China now and the willing business partners in the United States that the Chinese Communist Party has found, and the issue of Holocaust reparations.
Yeah, that's a good question. Because what it does is it shows that we're not just talking about history, but something that can be used and is relevant to today. Their lawsuits have been filed against corporations that have been engaged with authoritarian governments all over the world, not just China, and in which individuals living in those countries became victims as a result of the business dealings that American companies, European companies, multinationals have had. A series of these cases were before the United States Supreme Court. And again, unfortunately, I filed an amicus brief in one of those cases. This is in the Kiobel case, Kiobel. The United States Supreme Court said that those lawsuits cannot be brought in the United States. And so even though they're not lawsuits against a foreign country, they're against private companies. According to the Supreme Court, federal law, the way it exists now, does not allow this litigation, especially if you have a foreign company engaging in human rights abuses against foreign victims in a foreign country. There's still a possibility that if an American company is engaged in such human rights abuses, they could be, and if they knew about it and were involved in this, and the planning was actually done in the United States, there's an open question whether those lawsuits can be brought. So I'm now answering in the idea as a litigator, what can be done. The other part, and the part that's mentioned, by the question, is there's a campaign similar to the campaign that I showed you with Mercedes-Benz, to go ahead and to name and shame these companies. I'm trying to think of the clothing manufacturer that has a factory, Julian, and we don't know. We really don't know, but it looks like there's great suspicion that they are employing slave labor. Very much do you see the analogy as to what was going on in Germany. So I think it is a fair analogy to make, and to actually look at those particular prosecutions. I didn't have time to talk about this, but there were 3 trials in Nuremberg of German industrialists who participated, in the slave labor program. I'm not calling for another international prosecution. What I am saying is that international law that came out of Nuremberg dealing with, the heinous claims of the industrialists can be applied today to put the spotlight on these other companies. And it may work and it may change.
Thank you. I have a question from Elizabeth Eastman, who first thanks you for your very informative lecture, and then recalls that the theme of the lecture series is community or disunity. She asks, can we understand restitution as a means to rebuild community, or at least contribute to the effort of rebuilding?
Yes, but in very limited way. I think so much of restitution, and when you speak to Holocaust survivors, and now there are, Jews and non-Jews that end up getting, there's some measure of justice. What was really important for them is a recognition that, in fact, the perpetrator acknowledged the wrong, issued an apology. And as an example, in the German slave labor settlement, every single individual ended up getting that payment of $7,500 or $15,000 would get a letter of apology from the German president, acknowledging what was done was wrong to them and apologizing to them. And for many of these survivors, getting that letter in the 21st century was as important as getting as a one-time payment.
One of the things I found most fascinating in your talk, which I didn't know, was that the vote of the Israeli parliament was so close about whether to accept reparations, 61-50, according to my notes. And I wonder if you could say a little bit more about why it was that people like Prime Minister Begin, well, who would then become Prime Minister, Menachem Begin, were, I can see the grounds on which they were opposed. You were clear about that, but Elizabeth's question and your answer to it makes me wonder, was there something in particular that they wanted rather than money? The people who wanted to turn down the money, were they asking for an apology, or did they think that it was just so beyond the pale that there was nothing that the Germans could do?
Yeah, I showed you that slide of Menachem Begin speaking, and he was a young man at the time. Ben-Gurion was an older, the prime minister. And this was one of his momentous speeches at the time. We think of Begin as, during the Carter years, but this is a much younger Begin. And he talks about the fact that, look, we're taking blood money. We're talking about money. We're not going to allow them to feel that somehow they're exculpating themselves by going ahead and paying us. And there's no way, and he says in his speech, if we end up taking this, okay, so we get their money, we get their goods for a few years. But what do? We get shame as a result of this. And we're not going to go ahead and have that shame. And that's an issue that exists, in every one of restitution movements. If you do take the money, are you somehow minimizing the tragedy that occurs? If most all of your family died and you get a payment, are you saying that each one of my family members, my children, my spouse was worth so much, and now you exculpate the other side? And that's a difficult part. The other side of it is something that Ambassador Eisenstadt said. The only way to go ahead and get some measure of justice, at least on the American tort system, is by payment. And so, at least in the United States, we recognize that as kind of a form of symbolic justice, or as Michael Maris, I like his term, it's some measure of justice that was accomplished. And let me just add one more thing. Even in the Swiss bank settlements, the individuals that got the money, at whatever payment, or even that those ended up, getting the funds that came from Swiss bank account. Interestingly enough, people that we didn't know and knew, Sigmund Freud had a Swiss bank account that was not returned after the war. And his family came afterwards and ended up making, a claim because a list was published and they could see their names. It was really just a belated payment. It was not even close to the amount of money that the Swiss banks had profited as a result of dealing, with Nazi Germany during the war.
Thanks. We have 3 questions that are on pretty much are very, very close topics. And I wonder, none of them mentioned the recent Supreme Court decision unanimous Supreme Court decision. But that's sort of in the background of this, because there are questions about the United States and the issue of reparations now. So the first asks whether there should be a statute of limitations for Germany to make restitution, but one might ask in general about restitution. Is there a corollary to making restitution to descendants of slaves of the U.S. Confederacy? We might say more broader, the United States. Someone else asks whether the U.S. law you mentioned would allow or encourage countries in Africa, perhaps, to sue the U.S. government for the loss of their citizens and monetary loss when the United States imported slaves in the 1800s. Maybe if you could speak to these, to both that recent court case, whether you think that was on the mind of the court, and also how the issue of restitutions for slavery, how that, what you think about that in light of your talk.
Sure. I don't know what was in the mind of the justices, but obviously reparations for African Americans and what was done, during the slave era and even the Jim Crow era is something that we are paying much more attention to, today than we were before. In my Holocaust Justice book, I actually mentioned that the momentum of the Holocaust restitution movement brought one of the lawyers that was involved in this litigation, Michael Hosfeld, with a lawyer name you might remember, Johnny Cochran, who's one of the lawyers for OJ. And in the book, I have a photo of them as kind of being the new dream team to try to go ahead and bring lawsuits in the United States. They brought those lawsuits, and those lawsuits were thrown out on the basis of statute of limitations. With Germany, it's a different issue because we're dealing with individuals that are still alive. Unlike the issues going back, we don't have any, slaves that are still alive. Germany right now is prosecuting a gentleman who's 95 years old who worked in a concentration camp, and they're putting him on trial. And if they're saying that there is no statute of limitations for an act of someone being part of the, the murder machine in one of these concentration camps, then I don't think it's too late for Germany to acknowledge this, and that the statute of limitations should not really end until the last Holocaust survivor is still living with us.
Thanks. So another question on this topic mentions Bill HR 40 that was reintroduced in the House this past January to create a commission to examine reparations for the African-American descendants of slavery, and ask whether you think the Holocaust reparations process could serve as a model for slavery reparations in the U.S. Perhaps you've answered this to some extent in that there's an obvious disanalogy in that no actual enslaved people are still alive, clearly, and there are still a dwindling number of Holocaust survivors. Is there? But there is a bill, and reparations for slavery is a live political issue in the United States currently. Do you think that's more a political issue than a legal issue, given that the disanalogy that you've already drawn?
Well, for sure, as a litigator, I can say now that any lawsuit filed from African-American reparations will not be successful in the United States, whether it's filed against the United States or any of the companies that somehow you could trace, a railroad company today that somehow profited from slavery, or a bank that exists today that somehow was involved in commercial transactions involving slaves, because slaves were property. What is possible is to go ahead and say, look, there might not be a legal obligation, but there's a moral obligation. And because you carry the name of that bank, or you are the direct successor of that bank or that railroad company, that you really should go ahead and recognize the historical role. One of the things that occurred as a result of this Holocaust litigation against German companies is that they started looking through the records. So if you look at the website, for instance, of the German car companies or the banks, there was kind of a black hole in their history between 1933 and 1945. They sort of mentioned lightly what they were forced is to hire historians in order to go ahead and in order to determine their history. I'll tell you a brief story because it actually involves Chapman University. I got a call from a reporter, student reporter at Chapman newspaper. We have on our campus Einstein's Bagels. Einstein's Bagels is owned, is a subsidiary of a German company, closely owned. And that company, they just found out in the last 2 years, was closely involved with the Nazi regime. So the question I had to have, well, do I stop having Einstein's Bagels as a result of that? But I can say that if I sued Einstein's Bagels or this company in the United States, I would lose. But as a recognition of this company in Germany established a fund to go ahead and help destitute survivors. And the question that we can always talk about is, well, once you go ahead and establish a fund, maybe some of this money should go to other victims of other atrocities. And that's a moral, philosophical question that we can go ahead and talk about.
Thank you. On that note, I'd like to thank you again for a really fascinating talk. And unfortunately, one of the troubles with Zoom is that there's no good way for the audience to express their gratitude to you. So let me, on their behalf, thank you again for coming to the Benson Center, and remind the audience that Professor Bazyler's books are available at michaelbasler.com. Thank you all.
My pleasure. Thank you.